original intended filing. The bill seeks the repeal of 3 sections that currently authorize the unwarranted seizure of firearms without any semblance of due process. Under existing statute 173B4 temporary relief, the law permits the issuance of temporary or emergency protective orders based on nothing but a vague allegation of domestic abuse or stalking. In New Hampshire and elsewhere, these temporary restraining orders are nearly always granted by judges, even when the petitioner does not even allege any abuse or stalking. The petitioner simply asks the judge to approve the temporary order. These orders are then executed without the defendant's knowledge. As a matter of routine, police officers generally seize all firearms, ammunition, and other weapons from the subject of the order. The sections we propose to eliminate are those that empower the confiscation of firearms, ammunition, and deadly weapons by a police officer based solely on these temporary orders. Such mandates gravely infringe on an individual's fundamental rights without the requisite due process or evidentiary support. We are challenging the notion that mere allegations, sometimes with zero evidence, should be suffice to strip an individual of their constitutional rights and personal property. The low threshold for issuing such orders is dangerously akin to red flag gun laws, which have been a subject of intense debate and legal scrutiny. Notably, the case of the United States versus Rahami is currently pending before the United States Supreme Court after a decision from the Fifth Circuit invalidating federal law prohibiting individuals from possessing firearms while under a restraining order, casting doubt on the constitutionality of prohibiting individuals from possessing firearms while under a restraining order. This case underscores the pressing need to reevaluate and reform our approach to such sensitive and impactful legal instruments. Our objective is not to diminish the gravity of domestic abuse or the importance of protective orders. However, we firmly believe that the process of depriving individuals of their natural and constitutionally protected rights must be approached with the utmost rigor and respect for due process. The current mechanism, which allows for this precipitous and unchecked removal of one's right to bear arms, unverified assertions, is a glaring affront to the principles of justice we hold dear. Oftentimes, after the execution of these temporary orders, the subject of the order will retaliate and get a protective order on the original accuser, and then that person will lose their rights to bear arms as well when they're in a situation where they may be some sort of abuse. In essence, this bill, fortified by its accompanying amendment, represents a step towards safeguarding the constitutional rights of our citizens while ensuring that any actions to protect the individual from harm are judicious, evidence-based, and firmly rooted in the principles of due process. I urge you to consider the profound implications of current law and join me in supporting this essential reform. And with that, I will take any questions from the committee. Thank you.
Thank you, Representative. What is the current status of the case you cited? Has the Supreme Court granted certiorari on it? Do you know?
Excuse me, say that again?
Has the Supreme Court granted cert on that case yet to take it, or is it still at the Fifth Circuit?
The Fifth Circuit has already invalidated the law, and the Supreme Court will hear the case.
Okay, thank you. Any questions for the representative? Seeing none, thank you for your testimony.
Thank you.
Who's next? Chair calls Pamela Keilig and Jessica Vaughn. Martin.
Good morning, Mr. Chair and members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. And I'm joined here today with my colleague, Jessica, who's an Executive Director from one of our member programs, and we're here to represent our network of crisis centers. As you know, the Coalition is the umbrella organization for the state's 12 community-based crisis centers that serve more than 14,000 survivors of domestic and sexual violence each year. And that also includes victims of human trafficking, stalking, and child abuse. And I'm here today to emphatically oppose HB 1064, which is incredibly dangerous legislation that would keep deadly weapons in the hands of abusers in New Hampshire. And I would also be opposed to the proposed amendment that was just brought forward now. And just to quickly answer the question, the Fifth Circuit Rahimi case has already had the oral arguments in front of the Supreme Court. So just kind of to quickly overview just how dangerous this legislation is, more than half of all domestic violence homicides in New Hampshire are the direct result of abusers. So that means that most of these homicides involve a firearm or deadly weapon, and offenders are responsible, like I said, for the majority of these homicides in our state. So the question that I would really like to ask the committee this morning is, why are we even debating a bill that would keep deadly weapons and firearms in the hands of abusers? This bill seeks to repeal a crucial provision that currently exists in New Hampshire's domestic violence statute, RSA 173B. If this bill were to pass, police would no longer seize an abuser's weapons after an arrest for violating a protective order, even if the abuser used the weapon to abuse or threaten their victim. This is outrageous, especially when we know that an abuser's access to a firearm increases the risk of domestic violence homicide fivefold. When an abuser violates a protective order, this is a signal to their community that they are comfortable completely disregarding a court order and that they are completely fine breaking the rules and the laws of the state. And I think what's really important to understand is that when a domestic violence protective order is granted, a judge has already found by clear and convincing evidence that an abuser is an imminent and credible threat to the victim's safety. Current law takes the crime of domestic violence seriously and recognizes that when an abuser knowingly violates a protective order, they pose a significant risk and threat to the victim and the public. Failure to remove firearms and deadly weapons from the hands of abusers will only lead to more domestic violence cases, more injuries and deaths that are 100% preventable under current law. Abusers must be held accountable for the violence committed against their partners, family members, and children. In recent weeks, communities across New Hampshire have been reeling in the wake of several horrific domestic violence homicides. Passing this bill would send a clear message to communities mourning these tragic losses that members of the New Hampshire legislature aren't invested in the safety of their citizens. Just to kind of wrap up, we have an opportunity to make our communities safer, and instead we are here this morning fighting against outrageous legislation that is trying to turn back the clock to the 1970s, a time when systems of accountability for domestic violence offenders were simply non-existent. With so many pressing issues facing victims and survivors in New Hampshire, it's inexcusable that this bill is even up for debate in 2024. Long ago, the state legislature recognized the seriousness of domestic violence in our communities, and this bill is an open invitation for future violence and has no place in our state. I would also just like to note that stalking and domestic violence can be co-occurring, and when stalking is present in a domestic violence situation, the victim is 3 times more likely to be murdered by their abuser. I would like to now turn it over to my colleague.
Good morning, Chair and members of the committee. My name is Jessica Von Martin, and I am the Executive Director of the Crisis Center of Central New Hampshire. Our agency is the Domestic and Sexual Violence Agency serving Merrimack County. Our office is right here in Concord, and each year we serve between 1,200 and 1,500 unique survivors of violence that includes people of all genders, ages, and orientations. As the leader of that agency and an advocate for domestic violence survivors for almost 25 years, I am here today to express my strong opposition to this bill. As you can imagine, our team supports survivors in their lowest moments. We placed 49 individuals into emergency shelter last year, helped 11 families flee the state due to safety concerns, and supported the filing of more than 140 domestic violence protective orders in 2023. Our staff and volunteers hear daily the stories of violence that people face and the fear in their voices. Protective orders are one of the few ways survivors can create protection around themselves and their families, and this bill, as written, would effectively remove those protections and increase the likelihood of injury and death in our state due to domestic violence. For example, a recent example, a woman we were supporting to get a protective order, which was not granted on the first time around, I will add, was living in a basement and would not leave her house until she received confirmation that all weapons had been confiscated by local law enforcement. The perpetrator had multiple guns, which he had held to her head several times before she left. She was so fearful of being found, she stayed hiding in that basement for more than 3 weeks, refusing to leave for food, work, or anything. In this instance, a tragic outcome was avoided, but what could have happened if he was able to hold on to his weapons? If perpetrators are allowed to keep their guns after that kind of behavior, these are the lengths survivors will need to go to keep themselves and their families safe. We already know, as Pamela said, that many homicides in New Hampshire are related to domestic violence. Therefore, I'm asking this committee to oppose this bill so we are not adding to those numbers. Thank you for your time and consideration of this bill and the work you do to keep New Hampshire safe. I'm happy to field any questions.
Representative Newman.
Yeah, I have a question. In the previous testimony, we heard that these orders are based on allegations. And we also heard that there's no due process. And a lot of times we hear that these guns are confiscated. Do you have any comments on those allegations?
Sure. I will share with you that although we supported 140 domestic violence petitions in Merrimack County last year, many, many, many were not granted. And so there is a matter of due process, and there does need to be compelling evidence of an imminent threat.
Yeah, only about a third of final protective orders are granted in the state. The process to receive a protective order is extremely stringent and has a high bar. Like I mentioned, there needs to be clear and convincing evidence of a credible present threat to the victim's safety, and that includes a variety of different statutes under 173B.
If you could, a second, could you tell us about how long the period is from the original order to the hearing on the final protective order?
So from the temporary protective order to the final hearing, usually it needs to happen within 30 days and typically is within that time frame.
So normally firearms are seized on the temporary order and held at least until the final order hearing is held. At that time, is it your understanding that if the order is not granted, the firearms are returned?
Yes, but the temporary restraining order has the same credible present threat standard. So it's not like there's the same standard. It's the same criteria.
Except for one is ex parte, the defendant isn't present at the temporary order, correct? That's usually done.
Yeah, and I know that there are some folks behind me that can better answer some of those legal questions.
Thank you. Representative Newman, your follow-up question? Oh, okay. Representative Saley.
Thank you for taking my question. I'm curious, of the domestic violence homicides that occur in New Hampshire, what percentage of those are, does the perpetrator use what we would consider a deadly weapon, firearm, or ammunition?
It's about 50%. It fluctuates every couple of years, but it stays pretty evenly at about 50%.
Questions? Thank you for your testimony. The chair calls Mr. Elliot Axelman.
Hello, thank you very much. So my basic understanding is there was miscommunication with the sponsor on OLS. The intention was to strike not that part, a different part. There are a few different parts, different sections of RSA 173, the primary statute that authorizes the restraining orders, which function as red flag laws. One of the parts directs law enforcement to take possession of all firearms, ammunition, and weapons initially when the order is served. And that's an emergency order, a temporary order. And then we go from there to the final order. Another section of RSA 173 says if a person violates the order, continues to abuse the person with the protection order, and they're arrested, then police can do certain things, including seize firearms, which is redundant. My understanding as a sponsor did not even mean to strike that part. That's fairly reasonable if you're arrested for violating it. It's the initial serving of the order. To correct some of the previous testimony, the big thing that there's disagreement on is due process, but also how easy it is to get the orders. I have some evidence in a folder here I'll share with the committee, and we can make copies. that prove, with the judge's signature, that these emergency orders and temporary orders are granted with, I think someone said an extremely high bar. I would say an extremely low bar, but actually non-existent. So if you look at RSA 173, which is the statute that creates the restraining order, and RSA 633 stalking kind of points to that statute for the criteria. So really 173 is the primary statute. It says there should be a threat. There should be, some evidence or an allegation saying, hey, that person either stalked me or did domestic violence. There have been cases, which, I have proof evidence of with the judge's signature, where a person did not even make an allegation, just said, I want an order. I didn't make an allegation, said, I want to be protected from this person, and the judge approved it. And then police went to the person's home, seized about a lot of firearms and ammunition from that person and relatives and other firearms that were in that property, and that person is now out a substantial amount of their net worth. And that's a taking. As far as eminent domain, SCOTUS case law says that's obviously taking by a long shot because they took the property. As far as getting it back, there's another bill that Representative Mannion put in to give it back, but you don't get it back right away. So at the final hearing, previous testimony was correct that the final hearing, there should be a higher bar, and that's for a year. So within 30 days, you get a chance to go to court and have some due process, and then the judge is supposed to have a higher bar to approve the order for a year. And then if it's not approved, the order is dissolved. But then to get your firearms back, you have to go again to a different judge, get a lawyer, go to a judge, ask for a court order to compel the police to give your guns back. And then you can go to the police station, and then generally you have to pass a NICS background check. You'll have to prove that all the firearms and ammunition is yours based on serial numbers, registration, receipts, and all that stuff. And according to RSA 173, I believe, according to the state law in New Hampshire, police can charge you fees for every day. And I've heard of some exorbitant stories of the fees amounting to ridiculous numbers for doing the privilege of holding your property for you. And it says they could damage your firearms and ammunition and lose them with impunity. So that's interesting too. So people are losing value. And again, what this all comes down to is it's very simple, is a lot of people said, there are abusers. We have to protect victims from abusers. There's a reason due process exists. If some people think the founders were brainless for writing the Fifth Amendment, I would disagree. There's a reason the Fifth Amendment is there. There's a reason we have courts. It's to adjudicate guilt. If we're going to presume people guilty based on one person's extremely low bar allegation, or in some cases, no allegation, just a request for an order, which can ruin a person's life for a lot of reasons, that order, there's a reason we adjudicate them as guilty. So others today have said, others elsewhere I've heard say, do you want people who have guns and beat their wives and stalk people and use guns and shoot their wives to have guns and have freedom and never be punished? No. Like someone mentioned, a person put a gun to their wife's head. Absolutely, that person should be very swiftly arrested, prosecuted, convicted. It could all happen within a day, 2 days, 3 days, and then put in prison for however long the sentence is. But if we're going to skip that and punish them, arrest them, take their firearms, punish them, convict them essentially, then why do we have courts? So what I would propose is getting rid of courts. We could save taxpayer money. We all love that. Get rid of courts. When police go to a home, they'll declare the person guilty, throw them in jail or prison, and it'll be more efficient. Why have courts? So I would ask any opponent of the bill, why do we have courts? It's to adjudicate guilt. There's a reason we have due process. There's a reason the founders said we have presumption of innocence. We're supposed to be presumed innocent. And I think everyone on this committee understands that. If someone commits an act, and we've seen, the Boston Marathon bombers, people committing 9/11 terrorism, like murder in broad daylight, still they're presumed innocent. You can't even call them a criminal. You have to say alleged criminal. Otherwise they sue for defamation, right? You can't even call them convicted. So some would even say the statute calling them a victim is like saying the person is a convict. They should be alleged victim, alleged criminal, alleged abuser, because there's been zero due process. Something else that maybe we'll get to in another bill or an amendment or a later year is there are remote hearings. So the emergency and temporary order granted by a judge telephonically, a cop calls a judge in 2 seconds, signature, and then it's approved and the cops take the firearms and stuff. They say, we can't waste any time. We can't waste a second. The person, we have to take their guns. They're dangerous, and forget due process. We don't have time for that. we have video, and I know this because in New Hampshire courts and all over in federal courts, they have remote testimony. So why couldn't an amendment to this bill or a new bill, why couldn't the judge, when he gets the application for the order, since they have all the info on that sheet anyway with the address and phone number and all that of the subject of the order, the defendant, why can't they contact them and at least ask if they would like a remote hearing to defend themselves? And, you know, they can appear maybe via remote hearing and defend themselves and have some due process. So that could happen. We have the technology. We can do that easily. So those are a few of my big points. I'm happy to take any questions anyone has, any concerns.
Any questions for the witness? Thank you.
Thank you very much.
The chair calls the Honorable Representative David Love.
Thank you, Mr. Chair, and thank you, members of the committee. For the record, my name is Representative David Love. I represent Rockingham 13, which is Derry, and I guess I could do a little personal experience. You know, back in 2005, my ex-wife took out a restraining order on me. I never laid a hand on her, and you know, she had no reason to. 5 days later, I was allowed to have a hearing. They had taken my guns, by the way. And, you know, they gave me a hearing, and my lawyer walked up to her, and at the time, there was a perjury statement on the bottom of the restraining order that she had to sign. And my lawyer walked up and said, look, we can prove you've lied. We'll press perjury charges if you don't rescind this right away. She did. Okay. You know, proof that these restraining orders are used as a weapon. Okay. A few years later, there was a hurricane forecast and stuff, and I had been helping this Vietnam vet, and he had some mental problems, and he had a Jeep with a rag top on it. And he came by my house and he said, can you help me put the rag top on? And, you know, before the hurricane. So, you know, we did. And when the hurricane came, it blew the rag top off. And he came to me and, you know, he was serious as a heart attack. He said, you owe me $800. So I laughed at him, you know, and, you know, he got all kinds of mad. And he went to the Derry District Court and convinced the judge that that on the restraining order, it said that I was looking to take over the country. I owned many guns. I was a bodybuilder. I get one of these things. You know, I'm a bodybuilder, like you know, like a hole in the head. But anyway, you know, it was a lie once again. He went down to the clerk's office to get the paperwork after the hearing, and there were two men there that I knew, and he stood there and he looked at one of them. He knew him too, and he said, you know, good. It's almost hunting season, and I got his guns taken away. Once again, used as a weapon. Okay, I beat that again on the 5-day thing. But at this time, there was no perjury statement on the form. Okay, which I'd like to see an amendment to that. But anyway, getting back to the bill, you know, an abusive spouse or anybody can use a car, a steak knife, you know, they use planes, and the bombs they used down in Texas way back when. You know, if you want to kill somebody, there's a lot of ways. There's men on this committee that could kill a 120-pound woman with their bare hands. So what are you going to do? Handcuff everybody? You know, handcuff somebody? You know, without due process, this what we've been doing is absurd. It's a violation of the Second Amendment and our Article 2A in the New Hampshire Constitution. You know, we need due process. You know, I was guilty of nothing in either one of those cases. Yet I lost my rights to keep and bear arms. You know, it was the first case with my ex-wife. It took me 8 weeks to get my guns back. Okay. You know, I had to file for another court hearing and, you know, go through all that. And, you know, after 8 weeks, they had to give me my guns back. The second time, a member of this committee at the time, Representative Guy Comtois, had introduced a bill and had passed to reduce that to 21 days. So 21 days after that 5-day hearing, I got my guns back. Once again, though, you know, if it's 10 minutes, it's a constitutional violation. You know, and you know, if we allow the government to abuse any of our constitutional rights, you know, which one's next? You know, where do we go from here? You know, and if they're going to take our Second Amendment rights away, they'll take any right away. And, the Second Amendment is there to protect the rest of them. And, I just think that all along we've been doing an injustice, to freedom. And, it'd be nice to see this changed.
Thank you, Representative. I have just a couple of quick questions with regard to your personal incident. Could you explain to us the process about getting your firearms back? There was previous testimony that you had to prove after they took your firearms. Did they give you a receipt indicating what they had taken? And were you required to prove ownership of each firearm?
No, I wasn't required to prove fire ownership. On the first one, there was a shotgun barrel that I never got back. They did not give me a list of what they took. The second time they did, the second time they were much more professional about it, and and that varies from town to town, jurisdiction to jurisdiction. It depends who you're dealing with, I guess.
And were you charged any kind of storage fee?
No.
Any further questions to Representative? Representative Pratt.
When you went to court to get your property back after you were found not guilty, did you have to get a lawyer to do that? Or did it cost you money?
The first time I had a lawyer.
Yeah, so that cost you money.
Yes, yeah. And the second time I went, pro se. And, I had witnesses, including a Derry police officer, as to what was going on. I was real confident that I was going to win, and I did.
Thank you.
Representative Muse.
Thank you for taking my question. What was the disposition of the domestic violence charges that were brought against you?
I didn't have domestic violence charges, just the restraining orders.
Just a restraining
Yes.
order?
Mm-hmm.
Thank you.
I would like to add, going back a little bit, that my brother and his ex-wife had a contentious marriage and stuff. She attempted to run him over with a car. Okay, once again, that kind of stuff it happens too. So how do we stop that? There's many ways to kill somebody. You don't need a gun.
Thank you. Seeing no further questions, thank you for your testimony.
Thank you.
Chair calls Attorney Stephen Endrins and Paul Hoverson.
Good morning, members of the committee. My name is Stephen Endress. I'm an assistant county attorney in the Merrimack County Attorney's Office. With me is Attorney Halverson, who is the Merrimack County Attorney. Both of us have been prosecutors for a little over 20 years each. Listening to, we oppose this bill. Listening to what's been said, it seems like there's a lot of focus on the abuser instead of the victim. I hear people talking about constitutional rights and the founders and their thoughts. I'd remind the committee that Part 1, Article 3 of the New Hampshire Constitution indicates when men enter into society, they surrender up some of their natural rights to that society in order to ensure the protection of others. And certainly, society has an obligation to protect people. And in this case, society has an obligation to protect victims. There is a balance between protecting victims and victims' rights to be safe and an abuser's right or a person's right to keep and bear arms. Certainly, 173B4 seems to recognize those competing interests and sets forth a framework. There is due process in 173B4 to have your firearms seized by law enforcement. For a temporary order, there needs to be a showing of immediate and present danger of abuse. That's someone has to go in front of a judge has to make that finding, and then the judge issues a temporary restraining order. That temporary restraining order it doesn't require, but it may direct the defendant to relinquish firearms and deadly weapons. Most temporary restraining orders, in my experience, have included that provision because that provision certainly makes sense. If somebody is an immediate and present danger of abuse, then it makes sense that a court would ask that they relinquish their firearms. It's important to note that that's a relinquishment of firearms. It's not a surrender of firearms. The defendant still owns those firearms. And as we've talked about, there is a process to get those back, which is also outlined in 173B5. And in addition to the process to get them back, within 173B5, if you don't want the police department storing your firearms, you can file a motion and have your firearms transferred to a federally licensed firearms dealer. You can sell those guns. You can keep those guns. You can transfer them to another person. You can do all of that while this temporary order is pending against you. In terms of how long the temporary order is valid for, I would note that currently in 173B4, if an ex parte temporary order issues, the defendant, the person against whom that order was issued, can request a hearing, and a hearing shall be held within 3 but no later than 5 business days. So this is not an extended relinquishment of firearms. This is, you get a hearing within 3 to 5 days. At that hearing, the permanent order under 173B5, there needs to be a showing of abuse by a preponderance of the evidence. The defendant is given notice of that hearing and has a right to be present at that hearing and has a right to present their own testimony at that hearing. If the court makes that finding of abuse, then the court shall order relinquishment of firearms, which is consistent with current federal law. Looking at the original bill, I was confused because it certainly didn't change the relinquishment of firearms in temporary or permanent restraining orders. I understand there's an amendment. The amendment that I'm looking at least today, still deals with 173B4, which is the temporary orders, but still wouldn't address 173B5, which would be permanent restraining orders. So under a permanent restraining order, there would still be a relinquishment of firearms. But certainly there is a balance in the statute, and the statute seems to recognize that. I'm not sure if you had anything to add.
Not to that so far.
That's all I've got.
That's all I have.
Yeah.
I do have a couple of things. I don't, you want to ask Attorney Andrews questions before? Thank you. Morning, Chairman Roy. Morning, committee members. I'm not going to repeat what Attorney Andrews covered. I think he outlined the statute fairly well. I do want to comment on a couple things that was testified to earlier and some of the questions that the committee had. The case versus about the Riami case out of the Fifth Circuit Court. I actually spent a couple hours last night reading through the Riami case. Oral arguments were last fall, and I looked through, there were about 40 or so amicus briefs filed in Riami. I looked through a number of them, looked through the facts of the original case involving Mr. Riami. And I just want to comment about what happened in Mr. Riami's case, because I think it's important. Mr. Riami and his girlfriend had an argument in a parking lot. He assaulted his girlfriend in the parking lot, fired a round out of a firearm in that same parking lot. He left, later threatened to shoot her if she had told anyone about the incident in the parking lot. She, the girlfriend, filed a request for a restraining order. It was granted. It was granted after a hearing, after due process, for a period of 2 years. And I'm reading out of one of the filings at the Supreme Court. That filing summarizes Mr. Riami's continuing behavior. The court found that Riami had committed family violence and that such violence was likely to again in the future. The court accordingly prohibited Riami from committing family violence or from threatening, harassing, or approaching his girlfriend or her family. It also suspended his handgun license. Now I'll paraphrase it. Suspended his handgun license, prohibited him from owning a firearm, but he went on to later violate that. He participated in a series of 5 shootings in December of 2020 and January of 2021. After someone who had bought drugs from him started talking trash, is the quote, on social media, he went to the man's home and fired bullets into it using a rifle. The next day, after colliding with another vehicle, he got out of his car, shot at the other driver, and fled. 3 days later, he fired a firearm in a residential neighborhood without striking anybody, luckily. A couple weeks after that, a truck flashed its headlights at Mr. Riami on a roadway when he was passed. Mr. Riami chased that truck down, misidentified another vehicle, and fired into that vehicle. Well, that's what brought Mr. Riami before the federal court for possession of a firearm in violation of 18 U.S.C. 922. If anyone deserved to be in front of the court, it appears from the summary of the record that it's probably Mr. Riani. The question comes then, and I circle back to what Attorney Endress said, is the focus here on the violator or the alleged violator or the safety of the individual? And I agree that at times, with enough due process, that we need to protect the victims in these cases. That's clear. I spoke with many of the county attorneys either directly or by email, and everyone I talked to is opposed to this bill. I'm sure they would be opposed to the bill in the amended format. I understand from talking with virtually all the chiefs by email or by telephone in Merrimack County, all of them are opposed to this bill. I'm sure they would oppose it in its amended form. I believe the Association of Chiefs of Police may also be in opposition to this bill, and I think they file written documents. It's worthy to note, too, Attorney Endress touched on this, surrender or confiscation. Big difference. It's my understanding, even under federal law, a person can have an ownership interest, but may not be able to possess a firearm. That's addressed within 173 regarding the return of firearms. Even in 173B9, when it talks about a violation of a protective order, in paragraph Roman 1, subparagraph B, it talks about the law enforcement agency shall maintain possession until the court issues an order directing that the firearms, ammunition, or other deadly weapons be relinquished, and specify to whom the person or the firearms will be relinquished to. The court in 2023 updated their protocols on just this very issue. Chapter 14 of their protocols within the court spells out the due process requirements of returning firearms, how they're returned, to whom they're returned, the hearings that are required. And as part of their statutory references, they go through the New Hampshire Constitution, Part 1, Article 2A. They talk about RSA convicted felons, false imprisonment, sale of handguns, penalties for attempts to purchase firearms, temporary relief, final relief under 173B, violation of protective orders under B9, 173B9. And they go on to address that. So there is due process throughout the application procedure, the initial issuance of a temporary order, a hearing for issuance of a final order, relinquishment of firearms, not confiscation, but a relinquishment during the pendency of a domestic violence restraining order or a protective order, and then a final disposition of those firearms, either when the individual is no longer covered by the protective order or wishes to transfer to a federal firearms dealer, like Attorney Endress mentioned, for subsequent disposition by sale. I'll submit this afternoon, because I only found it late last night, an article that came out in the Journal of Law, Medicine, and Ethics. It came out in the spring of 2023. It goes through some of the numbers and the dangers to victims of domestic violence involving firearms violence. The title of the article is Intimate Partner Violence, Firearm Injuries, and Homicide. I'll email that to the committee later on this morning for your consideration. But one comment in that I'll end with talks about the relinquishment of firearms. And in that article, the author mentions roughly half of states have addressed a gap, talking about a surrender gap in federal law at the time, by including specific state requirements for surrender of firearms upon imposition of permanent restraining orders. And it talks about that within the article. I commend that article to you for your reading and review, for statistics and an overview about the reason and need for these types of statutes. I'll gladly answer any questions and have any.
The only thing I would add is in reference to the returning of firearms. I know both Attorney Halverson and I have handled those hearings on behalf of the state, so we're happy to answer questions about that as well.
Certainly.
Thank you. That's actually my first question. Is it the current state of the law that if a permanent order isn't granted, that someone is required to go for a separate proceeding to get their firearms back? And why is that versus just simply saying the order's not granted, here are your firearms back? Why is the alleged perpetrator required to go through a separate legal proceeding?
173B5, section 10C says law enforcement agencies shall not release firearms and ammunition and specified deadly weapons without a court order granting such release. So the statute requires the police to have a court order to grant a release.
I guess my question is why, when the judge says I'm not going to grant this permanent order and hereby order the return of the firearms, why is there a second? It's an expense to the person to have to go get an, I mean, other than the fact that we wrote the law.
Right. I mean, that's what the law says. I don't know what the background of that particular sentence in the statute is.
Nor do I.
It just seems to me it would only make sense that if the judge doesn't find reasonable grounds to issue, the person should just have their property back without having to an expense of another hearing.
Yeah, there's some interesting statutes because it also talks about when police acquire property through any means that they have to hold it as the court directs. So we've certainly had, controversies over how long does something have to be in the police possession before we need a court order to return it.
Also, to the best of your knowledge, is there any requirement that a receipt, an itemized receipt, be given by law enforcement to someone when they seize their property?
I don't believe there's a requirement for an itemized receipt. All of the departments that I've ever worked with are very afraid, I think, of being accused of damaging property or losing property. So it's the type of thing where if you have money in your pocket, they're going to count it in front of you twice and have you sign that that's what the money is. So all the departments I've worked with have always kept an inventory of exactly what's taken. I've always seen itemized lists of exactly what's taken.
As have I.
I just simply have concerns if I had to prove that I own something that they took up from me, and go back and find receipts from something I bought 15 years ago, we'd be in problems.
I've never had any, I shouldn't say I've never had any issue of ownership, because I actually have a case now where a third party is claiming that it was their gun that was seized and they want it returned to them instead of the defendant. There's a presumption that property seized from a person is owned by that person.
Right.
And if multiple people live in one dwelling, all the firearms in the dwelling are seized. And then it's up to the individuals to go and kind of prove that was mine and not theirs. And then they can't bring it back to the dwelling. How does that work?
I don't believe all the firearms in the dwelling would be seized. It's the firearms that are owned or under the control of the person who the protective order has been issued against. If those firearms were able to be accessed by that person, potentially they could be seized, but I would assume that you could restrict access within the dwelling.
Representative Rhodes.
Thank you, Mr. Chairman. My first question was going to be about an itemized inventory, if you will. So with that question already being answered, could you perhaps walk us through, like, say this, the person is the clear and convincing evidence has been found and they're going to go into this home and or place of residence and they're going to seize this property. Could you walk us through what that process is, or how they go about saying, is there things in this closet or they're under the bed? Or...
Right. I've never been personally involved in that process. My understanding from reading the statute and from talking to police officers over the years is that they would say first they're going to have a conversation with the victim and say, does this person have any firearms? And then they're going to have a conversation with the defendant and say, do you have any firearms? If so, this order requires you to relinquish them to us. We've certainly had cases where defendants say, nope, I don't have any firearms. The police don't then search the house. They're not ransacking it looking for firearms, because the statute doesn't authorize them to do it. It authorizes them to essentially receive from the defendant those firearms and the court orders the defendant to give them over. Having said that, if the victim says, yeah, he's got a gun, he has a handgun in the nightstand, handgun in the nightstand, handgun in the nightstand, and the defendant says, nope, no handgun in the nightstand, have always told the police what you need to do is obtain a search warrant, because you have probable cause to believe he's violating the protective order if you have probable cause to believe there's a firearm in the nightstand. So depending on what you're being told, you would then get a second warrant, which would authorize you to search the residence for firearms.
And that's addressed in 173B5 Roman 2. The defendant shall be prohibited from purchasing, receiving, or possessing any deadly weapons and any firearms or ammunition for the duration of the order. The court may subsequently issue a search warrant authorizing a police officer to seize any deadly weapons specified in the protective order and any and all firearms and ammunition if there is probable cause to believe that firearms and ammunition are kept on the privilege or residence or curtilage of the defendant. So they have to go through another due process step to even get a search warrant. So.
Thank you, Mr. Chair, and thank you for taking my question. Are you aware of a provision where a nexus or a background check is required by the police, even though there's a court order from a judge saying to relinquish those firearms? When the person shows up at the police station, are they now required to go through a criminal background check as well before the police release the guns or ammunition?
I'm not aware of a requirement for that. I know that in my experience, there have been individual police departments who will want to run the record a second time, but I don't know that that's required.
I think the courts, and I can't put my finger on it, I think the courts may run on domestic violence cases, do a NICS check, but that was, if I'm not mistaken, was that challenged?
Yeah, my understanding is that if the motion to return firearms, if the motion to return weapons is firearms, that gets sent to the state police who do a NICS check. If it's non-firearm deadly weapons, like if we seized a crossbow or that type of thing, then it goes to the local police department to run a criminal history.
Right.
Representative Newman.
Thank you, and thank you for taking my question. We often hear that ex parte hearings are unconstitutional and they don't provide due process. Do you have any comments on that, why it is? And I've also read that it is a waiver to due process as opposed as providing due process in temporary instances where there's a government need for that. So could you just comment on that and kind of help us straighten that out and what supports that as constitutional?
I don't know of necessarily a constitutional provision that specifically allows ex parte hearings. I think as a matter of sort of reality, you have to be able to do something quickly in certain circumstances. And throughout case law, they've developed standards for ex parte or temporary restraining orders. And interestingly, those standards tend to be higher than for a permanent order, because at the permanent order, the other party is present. As I read 173B4, I actually think that there's a higher standard to receive a temporary restraining order than there is under 173B5 to receive a permanent restraining order. And that makes sense to me, that there's a higher standard for the temporary order because it is ex parte. So I think that throughout, case law and jurisprudence, they've developed these standards for an ex parte hearing, which have withstood constitutional scrutiny.
Thank you.
With regard to the case law, I believe that is there more civil case law that kind of backs up the ex parte than criminal? For example, in a motion to dismiss, is the standard not always read in light most favorable to the non-moving party who's not available?
Yeah, in civil cases, you can get, restraining orders, temporary orders, and generally you have to show that there'd be irreparable harm if there's not an immediate order, and that you're likely to prevail on the merits to essentially stay the proceeding or keep things the way that it is.
And for all intents and purposes, although it falls within the criminal statutes, it's a civil proceeding.
This is a civil proceeding, yes.
It's the violation that falls
In the criminal,
moves
right.
it into the criminal world.
Thank you. Representative Selig.
Thank you, Mr. Chair, and thank you for taking my question. Just having looked at some of the online testimony as well, one of the things that's come up, and I don't know if you're the best person to answer this, or perhaps one of our police officers or other state's attorneys who might be present, says that we have essentially red flag gun confiscation laws in RSA 173 and 633. And I'm not sure if you're aware of that. Again, I'm still doing my own research to understand all of the details here, but that these types of orders are approved automatically by judges with no review. And I wasn't sure if you might have comment on that. And also on some of the online content that says that there's extremely high storage fees for those whose guns have been taken.
So with reference to red flag laws in 173 and 633, 633-3A is the stalking statute, which I assume is what they're referring to. Saying that these don't get looked at by a judge, a temporary restraining order doesn't get looked at a judge is just simply false. There is a standard in 173B4 in order to obtain a temporary restraining order. I've never attempted to obtain one, but I've been in circuit court almost every day for 17 years, and I've seen people obtain them, and I've seen people have them denied. I also know from speaking to members of the coalition and people from crisis centers who accompany victims to try and get these hearings that they're not always granted. I know from speaking to victims in criminal cases, they've indicated, I applied for a temporary restraining order, it wasn't granted. So certainly the statement that you fill out a sheet of paper and this is automatically granted is just not true. With reference to the storage fees, again, 173B5 section 10C addresses storage fees. It says the law enforcement agency may charge the defendant a reasonable fee for the storage of any firearms and ammunition and specified deadly weapons taken pursuant to a protective order. The fee shall not exceed the actual cost incurred by the law enforcement agency for the storage of the firearms and ammunition and specified deadly weapons. And then after that, it has the section about the defendant being able to make alternative arrangements. I've never encountered storage fees. I presume you could have the situation where you have a very small department that doesn't have a lot of storage and they seize a very large collection of firearms and they have to store it off site either by renting a storage locker or by going to a local gun dealer and having them store it. They can pass that cost along to the defendant, but they can't. This isn't the type of thing where you can say, well, our property officer, we pay him $50,000 a year to look at your guns, so we're going to charge you $50,000. The police can't profit on the storage.
And no upcharges, and the court protocol addresses that also and refers back to the storage costs addressed within the statute.
Representative Muse.
When you started your testimony, one of the things that you indicate, the reason you indicated you were here was really for the victims of domestic violence. Should this bill as amended or as proposed to be amended goes through, what would be the impact, do you think, on the number of homicides, the number of court cases that we see that are more severe? Are we talking about small impact? Are we talking about a significant impact?
I think it's hard to answer that. I don't have the statistics at my fingertips, but it's been my experience and from talking to other people that women tend to be murdered by people they know. Women tend not to be murdered by strangers in the night. It tends to be they're murdered by intimate partners. And knowing that reality and reading some of the horrific things we've read in police reports where people are subject to domestic violence, it's striking to me that if we have the opportunity this isn't like one of these things where it's like, oh, this random person may hurt me and has the ability to hurt me. This is literally a person pointing a gun at someone's head saying, I am going to kill you with this gun. And when that person finally gets to the point that they seek help from the state to protect them, it seems common sense to take that gun from that person.
Thank you.
I can comment on that. That article I'd mentioned I was going to provide, that 2023 article, it talks about that in there, and they cite some statistics, and they footnote it within the article, and that's why I want to submit the article separately. They talk about, and I quote from the article, more than half of female homicide victims are killed by a current or former male intimate partner, and 96% of murder-suicide victims are female. Firearms are used in more than 50% of intimate partner-related homicides. The article goes on to say about a page or so later, a victim or survivor of intimate partner violence is 5 times more likely to die when an abusive partner has access to a firearm. And again, I'll submit that separately, electronically.
Thank you for your testimony.
Thank you.
Thank you.
Chair calls Catherine Shackelford. Thank you, Sergeant.
Good morning. I'll be brief. My name is Catherine Shackford. I'm a sergeant with New Hampshire State Police, and I'm here today representing the Department of Safety Division of State Police in opposition of this bill. I'm not going to reiterate the information provided previously, so I will say that we absolutely agree with the statements provided by the coalition as well as the county attorneys that are here today, and feel that this bill would prohibit law enforcement from, excuse me, working towards ensuring the safety of victims and the general public, and it could lead to increased homicides in the state of New Hampshire. I would comment on 2 other things that have been discussed just from a state police perspective as well, to state that it is absolutely the procedure of New Hampshire State Police to provide an itemized receipt for all items seized. And we do not charge, and I've never heard of state police charging any storage fees. I can't speak towards local law enforcement, but I could state that absolutely comes from state police.
Thank you for answering those questions.
Could you just repeat that, what you said about the list?
I'm sorry, say it again.
They do
It's our
provide it.
procedure to provide an itemized list of all items seized. Yes.
See no further questions. Thank you for your testimony this morning. Is there anyone else present who wishes to testify who has not testified in this bill? Seeing none, I hereby close the public hearing. And I'm going to open the public hearing on HB 1073 and invite the sponsor to introduce this bill. Okay. Who? Yeah, he's there.
You called me up for 1073?
Yeah.
Correct? Okay. Good morning, Chairman Roy and members of the committee. I am Representative Stanton Nastasso, representing the towns of Ringe, Jaffrey, and Dublin. House Bill 1073 repeals RSA 15838A, placement of simulated explosives. It reads, any person who places or causes the placement of a device simulating explosive or other similar dangerous substance or contrive in any location, thereby causing anxiety, unrest, fear, or personal discomfort to any person, shall be guilty of a Class A felony. The background for the creation of this bill was a constituent that was threatened with a felony charge under the statute for having a gag decoration on their car during a traffic stop. The constituent was ordered to remove the decoration or take the charge. He complied. The law's broad scope results in potential misuse and unjustified legal challenges. The issues with the current law is vagueness and overreach. The law doesn't distinguish between actual threats to public safety and harmless objects. Common gag items like at auto shops, commonly you'll see a gag with the grenade. It says complaint department, pull the pin. I think that would, if someone got anxiety from that, they could the shop could be charged with the Class A felony. I lost my spot. Sorry. Found places like auto repair shops could be misconstrued as violations. So subjectivity and potential misuse, a singles person anxiety, irrespective of context or intent, can lead to a felony charge. For example, sometimes people have things like pretend claymores in yards. There's this new business model called an escape room, where you go into a room and the actual intent is to cause anxiety. There could be some sort of fake explosive there. So I think that this could be misconstrued to charge those people as well. An unnecessary legal burden. So even if courts dismiss such cases, which I hope they would, in instances such as the constituents case, if it had been prosecuted, the accused undergoes unnecessary legal processes, which themselves are punitive. So real life implications. In the case of my constituent, the result to remove the gag decoration to avoid a felony charge highlights the law's excessive scope. This situation exemplifies the need for legal clarity and fairness. Obviously, it's not a good situation when someone purposely causes a panic by placing a simulated explosive for obvious reasons. Therefore, it's reasonable that the committee may not want to just outright delete this. And I think the concerns could be solved by a couple of amendments. So to address the concerns while ensuring public safety, I suggest following amendments. So location specificity. Private property should be exempt from the law, so you should be able to put whatever you want on your own property. Intent, so the law should require demonstrable intent to cause a panic. Reasonable standard, the law should consider if it's reasonable for the situation to cause anxiety. And impact threshold, a felony charge should require more than one person's discomfort. So in conclusion, I'm ready to work with the committee to draft an amendment that makes this bill reasonable and fair, makes this law reasonable and fair, ensuring public safety without over-criminalizing innocent behavior. Thank you, and I will take questions from the committee.
Thank you, Representative. With regard to the gag thing on your constituents, was it a trailer hitch thing that said Claymore?
I'm not exactly certain of what the actual the device was.
Because I'm pretty sure I when I had a pickup truck, I had one. Okay. It's a trailer hitch cover that says "face towards enemy."
I have seen that exact thing. I just don't know if it was the one in the case of my constituent.
Anyone who's ever actually used an actual Claymore knows that they don't look like that at all, and there's much more required to use. Okay, thank you. See no further questions. Thank you for your testimony.
Thank you.
Chair calls Captain Brendan Davey. Oh, but this needs work.
Good morning, ladies and gentlemen. My name is Brendan Davey. I'm a captain with the New Hampshire State Police with 1 month shy of 23 years of service, 16 years in patrol, 7 years at headquarters with recruitment and training, policy and compliance, and now field area captain. The Department of Safety, Division of State Police, stands in opposition to this bill for the reason that to delete, as its sponsor has stated, this provision in its entirety is to leave the public at risk to the specter, which I submit we increasingly see, swatting calls and hoax devices at the end of the day. I do not disagree with the bill's sponsor that amendments could be in order. A felony requires a culpable mental state, and a culpable mental state ought to be put into this law. A reasonable person standard is built into a criminal threatening statute, for example, and that could be built into this law. I would submit that the improvidential decision of one police officer is not reason sufficient to warrant deleting a law, removing from law a proscription on behavior that in many cases is utterly reasonable in terms of the response that it provokes, and needs to be so in the age of terrorism from both foreign and domestic actors. And I would submit that the court would protect that citizen as they did in the case of a loaded firearm, where the law is clear and a police officer misread and misapplied. So that concludes my testimony in this matter, and I'd be happy to take questions.
Thank you. And your comments regarding a reasonable person and certainly intent are well taken. I'm reading the statute. It doesn't mention intent, and it seems to me that should be the whole point of the statute, would be with placing something with intent to cause fear and anxiety, not just simply having something. But,
yes, sir.
Any further questions for the captain? Seeing none, thank you for oh, I missed one. Representative Muse.
How often do you see something like this? How often does it come up?
In an effort to understand the scope of this problem, just with state police, sir, I did look up for the last calendar year, 2023, the number of bomb squad responses. So we get a suspicious package, a backpack left somewhere where it raises the suspicion of members of the public, and over that period of time, I know that our bomb squad handles something on the order of 800 calls for service per year. Many of those are relinquishments of old ordnance. People find ammunition in their basements that belong to family members who've passed away, things of that nature. So it's difficult to say what the number of these is. I can tell you it is significant. When we get a suspected device somewhere, the scope of the response that comes to that when we have yet to determine that it is a hoax it's of a magnitude that's very expensive in terms of all form of resources, and it's very disruptive to people's lives. That said, to decriminalize what would reasonably result in that response is just a bad idea.
Thank you.
Yes, sir.
Representative Salig.
Thank you. To follow up on that, I'm curious. So if hypothetically there was a threat here today, right now, what would be the, how does the squad get activated? And then what's the cost for dealing with and just, identifying either that it's a hoax device or detonating something because it can't be determined prior to detonation whether or not it's a hoax device?
Cost is difficult to calculate, ma'am, but if there were a call in this building right now, depending on the quality of the information, this whole place could be cleaned out, entirely disrupted. Staff used to look for and identify a device. Law enforcement brought in to manage traffic and keep people out for a certain blast radius based on the description of the device itself, because it's not direct exposure to the device that can kill people. It's compressive blast as well that will damage aqueous organs and kill people as well. So there could be hundreds of police officers here in pretty short time, and extremely disruptive. So many of those people could be called from other areas of the state or held out on overtime or activated from an off-duty status. And so therefore it would be very expensive.
But we'd get to go home for the day, is what you're saying.
Yes, sir. That was not a suggestion to anyone.
Just checking. All right. Thank you for your testimony. Oh, who? Oh, Representative Stone.
Thank you. And I'll be very quick. Any of the incidents that your bomb disposal unit responded to, did that involve any commercially produced items such as the gag gifts, such as the dynamite clock or the trailer hitch Claymore mine or the complaint grenade that you probably have seen yourself over the course of your career?
No, sir. And there again, it's the reasonable person standard on one side. It's a reasonable police officer standard on the other. I pointed out a Claymore trailer hitch to my wife the other day. See how it says point towards enemy? So,
Thank you.
Thank you.
I'm certain I have one in my garage because it was on my truck.
Yes, sir. I appreciate
Yeah.
that. We'll work on this.
I also
for
may
you.
have a inert old tank around somewhere, but I mean, it's, yeah. Representative Saitek.
I'd like you to further comment on the providential trooper or officer. If he saw an incident that could be arguably considered a felony A and offered the detainee the option to remove it, I think that sounds to me very providential.
Mm.
I mean, not. Would you want to rethink that adjective?
Not on the basis of the characterization of the event, sir. Its characterization was what was clearly a gag was used as, this is going to be labeled with my initials as Exhibit A in a felony case against you. So I think it heavy-handed, as described. That's all.
Thank you.
Yes.
There be no further questions. Thank you for your testimony. Anyone else wishing to testify on this bill who has not testified? Seeing none, I hereby close the public hearing. And I open the public hearing on House Bill 1599 and invite the sponsor to introduce this bill.
All right. Good morning, Chairman Roy and members of the committee. I am Representative Santanastasso, representing the towns of Rindge, Jaffrey, and Dublin. This bill affirms that the Second Amendment protects individuals' right to employ weapons capable of making decisions autonomously with the use of artificial intelligence. This affirmation is crucial as these kinds of weapons already exist. It's somewhat daunting to acknowledge our progression into an era where machines control weapons, but humanity will adapt to this new reality as we always have. A common image that comes to mind when discussing AI weapons is something akin to the Terminator. While it's probable that such weapons will exist, I want to first highlight a practical example where this bill will protect the public. So imagine a woman being mugged in a parking lot. An autonomous car, either hers or someone else's, is able to detect the situation and it determines it can intervene by pushing the mugger away. If allowed to act without human interference, it will do so promptly. Otherwise, it might require the woman to press a button to initiate the action. However, the woman may be physically unable to press the button or may not realize this as a viable solution. If the software can reach the same conclusion as a reasonable person would in the same circumstances, then it could be allowed to take the action without human intervention. We shouldn't delay these life-saving measures, especially as we move into an environment filled with autonomous machines. We shouldn't say, sorry, you got mugged, but the government demands that you first must answer a text message from your car before these defense measures are put into action. Furthermore, it's reasonable to imagine that in such situations, artificial intelligence might be better suited to using an appropriate level of force, whereas a person might be justified in using lethal force with something like a firearm without the protective intervention of AI. Just in the same way, self-driving cars are expected to cause less accidents than human drivers. So AI can infer the image of someone looking at, it can infer the image that someone is looking at based on just a scan of a brainwave. So the what AI is going to be able to infer about what's going on is going to be it's going to be with perfect precision. So the world we're moving into with this stuff is going to be so foreign that in the future, in order to describe the way we live today, will only be possible, I think, in religious terms. AI-driven weapons have the potential to offer greater precision and reduced collateral damage compared to their human-operated counterparts. These systems can make rapid calculations and decisions based on a multitude of factors, aiming to neutralize threats with minimal harm to bystanders and infrastructure. This precision makes the use of force more ethical and also more effective in complex real-world scenarios. A couple other examples that could be a reality, like today you'll hear there's stories where high-speed police chase is going on and it's stopped by a trucker who saw the situation and then moved his truck into that lane. The suspect is driving in, causing an accident, and then potentially saving lives that could have been caused if the pursuit was allowed to continue. So I'm saying that someone's autonomous car in a parking lot could, maybe has assist police mode turned on by the owner or something like this. It could be alerted to a similar situation, stop the car because it's physically positioned in a strategic location that benefits the police by chance. Or maybe 5 cars could be activated and just block the road the driver's going down ahead of time. So it's not that, I think they're going to outfit your household toaster with the firearm inside it or something, but that, it already exists. So maybe it has intelligence. It can detect these situations, and it can maybe do something to mitigate a situation. There'll be hardware all over the place that we should leverage for our advantage. Things like automatically locking doors and rooms until police arrive. That's a use of force decision. Turning on and off lights. There's robot vacuums. I don't know. People come up with things, and they're very creative. Firearms have been called the great equalizer, where a 5-foot woman armed with a handgun can defend herself from a significantly more powerful man. This is true, but it requires that the woman learn and understand how to use a firearm and stay current on training, learn safety techniques. AI weapons will be even more so an equalizer, to include those who are unable to wield firearms and are unable or unwilling to learn how to use them, and providing safety and defense capabilities to those who might otherwise be physically vulnerable, like the elderly or disabled. So a crude version of a weapon that has the ability to make a use of force decision has already existed for centuries, things like booby traps and landmines. So booby traps they're outlawed by numerous case law. Example of a booby trap is like a shotgun with the trigger tied to a door, so such that when the door opens, it kills the person opening it. So that's some binary intelligence there. It just kills whoever opens that particular door. So the bill states the decision of autonomous artificial intelligence is subject to the same standards as described in this chapter as if a natural person made the decision. If the decision of the autonomous artificial intelligence is deemed not justified under this chapter, justification shall not be available as a defense in any action or prosecution brought against the owner or employer of the artificial intelligence. So since it's unreasonable for a person to make a decision to kill based solely on a particular door open, this sort of weapon would not be protected by this. AI weapons are here. In March of 2020, a quadcopter drone with an explosive payload in Libya autonomously hunted down and killed a human target in a kamikaze-style attack with no human intervention after deployment, possibly being the first time a drone has been used to autonomously kill a human. The thing about these kind of weapons that are unlike the Terminator type movies that try to portray such things is when you see the hero evading the gunfire from the machine, in reality, the machine will never miss. The hero will not be running through gunpowder. It'll have near perfect targeting with the ability to predict your movements. It'll have a perfect shot every time. So without these countermeasures, we stand little chance against such weapons. Drones are inexpensive, and the software will be, if not already, readily available and runs on consumer-grade hardware, making regulation to prevent these weapons futile. AI software requires very powerful computers and massive amounts of data to create, but once generated, can run on consumer-grade hardware. For example, a stable diffusion model encapsulating a plethora of artistic styles, cultural nuances, and drawing techniques from a myriad of artists is compacted into less than 5 gigabytes. It isn't merely data. It's a condensed universe of human creativity and intellect. It's totally unbelievable that it requires so little disk space and is capable of running on an ordinary, standard, off-the-shelf computer. And once these models are generated, they are promptly leaked for the world to use, like Meta's Llama model, which made headlines in March of 2023 after being leaked into 4chan a week after its announcement. By acknowledging this existing right, we may open this industry up for development in New Hampshire, where other jurisdictions' initial reaction to AI will be an attempt to limit it, hereby making the government in that area less relevant as AI becomes more relevant. AI will greatly exacerbate asymmetrical warfare. So asymmetrical warfare is things like an American Humvee, and soldiers getting killed and destroying the Humvee with nothing more than just a single roadside bomb. AI will greatly increase this delta to allow a group with very small means the capability to destroy major targets. An example could be a malicious person or group could spend a couple $100 to purchase an RC helicopter or drone from Amazon or Walmart, outfit it with a computer and a bomb, and then instruct the computer to target a particular person using images obtained online. And then the helicopter could literally wait for the target to exit their house, fly up to them, and explode. This could be done from hundreds of miles away, or even a sophisticated attack from elsewhere targeting people based on ethnicity, political affiliation, or the religion. The AI could just look at people and just determine if they're of one of these groups. So a defense of this kind of thing isn't obvious with conventional means. Attempting to police everyone deploying such weapons would require a tyrannical government because you'd have to ban all sorts of hardware, implement extreme tracking on all purchases, and monitor all internet traffic and monitor all people because the stuff is it's going to be too easy to get. By allowing these weapons to exist without countermeasures will also lead to tyranny. As governments and potential hostile entities develop these weapons, it's vital that citizens also have access to comparable defense technologies to maintain a balance of power. This parity helps prevent a scenario where the general public is left defenseless against a more technological advanced threat, whether it come from within or outside national borders. That's why I believe we should affirm that the Second Amendment protects individuals' rights to bear arms for this next generation of weapons. Thank you, and I will take questions from the committee.
Thank you, Representative. For 20 years, I've wanted my own Terminator. I just don't know that I could afford it. Wouldn't you say this is regressive and that only rich people will be able to afford these things, and people of limited means will not? How much would one of these things cost? I would believe any type of automated system that would be capable of firing a firearm would be very expensive.
That's true. I can't afford my own tank. I'd like one of those.
Does that authorize?
That would be expensive. That's a conventional weapon that is available right now. So a lot of these weapons, I think, will be integrated into existing hardware, just like my examples with the autonomous cars. This hardware is going to be built, and it's going to be autonomous. There's going to be machines that do everything, like locking doors automatically and stuff like this. And I'm saying that locking someone in a room is a use of force decision, and this could be decided autonomously. I think better, potentially better than a human could make that decision. And since that hardware is there and the software is already there, it's just allowing it to do these things. And that's why there should be liability on the owner of the actual software.
Representative Prue.
So that was pretty much my question. I have all this stuff in my car or wherever, and it makes a wrong decision and kills somebody. Who's responsible for that?
Right.
Who's going to jail for that?
So just like one of the problems with self-driving cars is people are like, well, if the car makes an accident and kills somebody, who's responsible for that? And it's not that an accident will never happen, but accidents happen today. And I would just argue that there'll be less accidents. It'll be that the AI, just like in the self-driving, it's going to overall be better. But who would be responsible is the owner of the actual system. As it's
So if it's my
in the bill.
system and I tell it not to and it still does, I go to jail.
Well, I'm not exactly sure how the market's going to play out on it, but what I would suspect is that you would have a subscription to it. I don't know, the market could come up with all sorts of creative things, but I would suspect if you bought the car, the manufacturer of the car would provide that software, and they would take liability for it.
So we don't really have this technology to a point that we know what it is, know how proficient it is, how reliable it is, and we want to legalize it. Is that your premise of this bill?
Just like today, if you go ahead and make a use of force decision that's incorrect, right, you'd be prosecuted for that. So if you implemented a weapon that makes a use of force decision that's wrong, you would face the same consequence. So it's just affirming that this already exists.
Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. You mentioned, you're talking about autonomous cars and also, the facial recognition. And I'm just wondering, have you heard about the many stories of autonomous vehicles going awry and causing accidents that even the operator cannot stop. Cars that are being recalled exactly for that reason. Also, the discrimination that is built into the bias that is built into facial recognition. This has been shown, demonstrated time and time again. And, the thing being that an algorithm is still informed by people and still can be misinformed and reflect the biases of the people who create that algorithm. And I'm just curious, are you aware of that? And are you concerned about that with technology like this used for defense and things like that?
Yes, of course, but human operators have biases as well, and I think that the AI, it's the responsibility is still on the owner. Just as if the AI makes an erroneous decision, it would be on the owner. Just as a bad use of force decisions already.
Representative Newman.
Thank you. I'll just call your attention to I guess on page 2, that the line that begins on 23 that says, if the decision of the autonomous artificial intelligence is deemed not justified under this chapter, justification shall not be available as a defense in any action or prosecution brought against the owner or employer of the artificial intelligence. Could you just point me to anything in the bill, if I don't think there's an amendment to the bill, or anywhere else in this chapter where it defines who makes that decision, since this is a whole new thing about artificial intelligence?
Yeah, if it's not outlined correctly, we can fix it. If the bill's not totally complete, then we can work on that.
Thank you.
Representative Reed.
Thank you, Mr. Chairman. This is a frightening new era, and I'm really outside of my scope of expertise. But would this be hackable? Could China or one of our enemies hack into these AI things and cause harm? So, thank you.
Yes, that's actually particularly my worry, that there's going to be autonomous machines all over the place that could be hacked. But the problem is, I would rather live in the 20th century, but these machines are going to exist. They already exist. There's already cars that are built today are fly-by-wire. You're communicating with a computer when you control the steering wheel. It doesn't have a steering shaft. And right now, somebody could put software on those vehicles and make it do something erroneous. So this is, in my opinion, a way to protect against those kind of things.
Representative.
Thank you, Mr. Chairman. Thank you for taking my question. I echo what Representative Reed just said. I felt like we were in science and technology there for a second. This is a little bit out of my scope. But I also, my worry is that these technologies are there really self-defense or assist police technologies built into the Tesla cars? Or, what is the reality of what these devices are, what they can do? I'm just trying to get an idea of what the AI device would be and how it would be used as defense. Would people just be able to have these military grade quadcopters that were out in Libya, or are we talking about cars that are able to move to one lane or the other to stop an accident or something like that?
So things like these quadcopter things that are in Libya, that example I used, I believe that they're going to be way too cheap to produce. So anybody could make these right now. I think you could just go spend less than probably $1,000 and build something comparable to what hunted down that person in 2020. So because the threat is there, I think we should not prohibit people from using the same kind of technology to defend themselves.
And to answer your question, they are capable of programming all kinds of things into cars. If the government mandated it, they could program a kill switch into most cars that the police would just be able to shut it off.
I have seen that, yeah.
Representative Muse and then Representative Pugh.
If you see this technology as being such a problem, Why doesn't your bill just make it illegal?
The reason why is because I don't believe it's possible. I think that by making it illegal, the only way you could carry it out would by having an extreme tyrannical government. Because what does it cost to buy a drone? I mean, they cost nothing, and bombs and the software is readily available. They can't protect the software, and it runs on a regular GPU. You can run these advanced AI, what do they call them, like large language models and the neural networks and stuff, and have it create artwork and come up with. It can write entire books, on a hardware that's cheap. So to prohibit people from having that it's impossible. It's too easy to construct.
Thank you.
Representative Prue?
Are you aware that armed drones are already illegal in the state?
If they're illegal or not illegal, you could just buy one.
I understand that.
They're specifically mentioned as illegal for use in surveilling or chasing game by taking of game. Seeing no further questions, thank you for your testimony.
Thank you.
And the chair calls Captain Davey again.
Thank you, ladies and gentlemen. Again, I'm Captain Brendan Davey with New Hampshire State Police, just short of 23 years of service, and 15 and a half of those on our SWAT team. I've seen a YouTube video of a quadcopter with a Glock pistol attached to it. It's one of the more frightening things I've ever seen, despite the real things that I've seen that are quite frightening. I would submit to you that many of the sponsors' responses to your questions were indicative of his hesitation to trust this technology, and the Department of Safety's standpoint and view on this legislation is in keeping with those hesitations, and we oppose it. Anything that removes the direct sense of ownership, agency, and therefore culpability in any use of force is not something that the state police would embrace, because it makes more difficult to hold to account the actions that resulted in death or serious bodily injury or deprivation of right in any other way. And so we oppose the bill. With regard to the use of AI, I would submit to you that genie is already out of the bottle. My understanding is that any system that has AI, that the mere inclusion of a few new lines of code is what can make an autonomous system or make an intelligent system to any degree autonomous. While I would agree that artificial intelligence, well used, very well designed, extremely robustly tested, can outperform humanity in certain tasks. Israeli defense mechanisms as they exist right now can identify an incoming rocket in 1 millisecond, where the human being is capable only of perceiving it at about 250 milliseconds and then limited further in its response time. Artificial intelligence is not prone to emotion. It is not prone to fatigue. Those are certainly advantages that can and will be made use of at some point in the future. As of right now, if someone flew that drone with a Glock on it in New Hampshire and used it to do harm to someone, state police would still have a case on our hands, and the Attorney General's office would expect us to investigate, prove ownership, prove agency, prove culpability, and secure a conviction if at all possible. I would submit that the main examples of the use of artificial intelligence for autonomous delivery of any methodology of force outside of this one Glock on a quadcopter are military, and therefore Elon Musk and his ilk are the only people likely to be able to employ these things with any significant effect. The use of AI in military situations is under intense scrutiny, and at the same time that is recognized that there is an arms race, that the country or state that develops these best and first and most readily will probably trounce those who trail. There are also serious ethical concerns that have been spoken to a bit here today. So for all the reasons foregoing, State Police and Department of Safety would oppose this legislation.
Thank you, Captain.
Yes, sir.
To the best of your knowledge, is there not currently available, for a significant expense, but available firearms that have a certain level of AI in them, in that they adjust for windage automatically, depending on the round and the distance? They actually adjust. They're called smart rifles. Some of them even beyond line of sight.
Yes, sir. I've read that there are such things. There are some computer guiding systems that do assist with munitions, as I understand as well.
Thank you. Representative Jambrin.
Thank you, Mr. Chairman, and thank you for taking my question. We've already established that sight guns are illegal, and that police officers and firearms defense experts who engage in don't shoot situations don't always agree on if they got it right, which leads to litigation. Do you believe that AI can take the place of a human brain at this point to make those decisions?
At this point, sir, no.
And follow up. Thank you, Mr. Chairman. Do you believe that the human brain can make mistakes?
Absolutely, sir.
Thank you.
Yes, sir.
Representative Wheeler.
Thank you, Mr. Chairman, and thank you for taking my question. So if someone were to use a quadcopter, commit murder, and the Department of Safety only saw the quadcopter, was able to get it down, how would you prosecute that person who launched that drone, if there was a way to do that?
Yes, sir. We'd have to determine ownership, control, and work our way back to the person who had conducted that act through technology, and that would clearly be a much more difficult thing than a person with a gun in his hand.
Thank you.
Yes, sir.
Representative Newman. I see.
Yeah, I just have a question that deals with the last comment. If I had my 9mm set up somewhere, automatically it would draw and
Wait a
fire.
minute. Did you just admit you have a 9mm?
What did I say? I don't remember what I said. Oh, do I?
Live free or die, sir. Go ahead.
Let me restate that. If a person had a 9mm and they had artificial intelligence at their disposal, and they could activate the artificial intelligence to immediately draw the gun and shoot at whatever is they deem to be threatening them. Do you see a difference between that, whether I pull the trigger or whether that person pulls the trigger, or whether they activate the artificial intelligence to do that? How would that work in the situation?
It's a difficult question to answer, but at the end of the day, what I would speculate here, that at trial, you're going to say that it was the AI that made the bad decision and not you. The problem with that is it's still all yours. And that makes securing a conviction for what ultimately would result in perhaps an unjustified loss of life still your responsibility, just a lot more difficult to prove.
I have a question to the chair. Can I just make a comment about something that air traffic control and automation that may be relevant to what we're talking about? And my comment would be that air traffic control, I worked in that for many years, both as one and trying to automate one. They've been trying to automate it since 1985. And the thing is, the human is still responsible for separating the aircraft, no matter what they are using to separate the aircraft. So the responsibility, in my opinion, comes back to the owner when they activate or use that. And they're the ones that are responsible for doing that. Thank you.
Thank you for sharing that. I agree. It goes back to the theology of the prime mover. Whoever set it in motion is the one who is responsible. Representative Sytek.
It sounds like your opposition is, or your position is not yet on this bill.
That's well said, sir. I have yet to speak the word premature, but the division would see this as that.
Seeing no further questions, thank you for your testimony. Is there anyone else wishing to testify in this bill who has not yet testified? Seeing none, I hereby close the public hearing. And what do we have left? Yeah, we're behind 10 minutes. I open the public hearing on HB 1237. and we're going to take a 15-minute bar break. Okay, at this point, I'm opening the public hearing on House Bill 1237. A little departure from normal. House Bill 1237, 1238 are very closely related. The sponsors requested to speak to them both at the same time, so I'm going to let him introduce them both at the same time. So keep in mind, we're talking about both bills in the interest of time. Thank you. Go ahead.
All right. Thank you to the chairman of the committee and the members of the committee. I'm, pardon me, Brandon Finney, Stratford 9, which is Rochester Ward 6. I'm here to introduce HB 1237 and HB 1238, which are about unmarked police vehicles and applying municipal police plates to said police vehicles. I want to keep it as concise as I can, in the interest of time and your attention. I want to harp on a couple of things. So essentially, what these bills are pertaining to is only municipal police departments. I've excluded the state police from the scope of the bills to allow them more flexibility in their operations. So I'm only talking about municipal, local police departments who would conduct any type of traffic enforcement, only, speeding, stoplights, that kind of thing. We're not talking about undercover investigations or any other type of criminal investigations. It's only about the enforcement of vehicle statutes. So the first thing I want to harp on is the idea of public safety. Currently, the way that the police operates, based on a 2005 Supreme Court Castle Rock against Gonzalez, the institution of policing is not under any type of constitutional requirement to protect or serve, which is what we've all come to understand what the role of police in our society is to do. In that case, their tactics have changed as far as how they enforce the law on the road and also how they tend to generate some revenue for the state. And the idea of not allowing unmarked police vehicles for the sake of enforcing traffic laws, and also having the requirement to have municipal police plates on the vehicle, so that everyone on the road can clearly see that there is an officer on the road who's conducting speed trap operations, either on the public road, even on some sections of highway. The goal here is to make sure that all the vehicles that are on the road that are used to pull people over for infractions have police on the vehicle, that we can see what department it's from, that it is an official public services vehicle. The stealth vehicles that don't have plates on them, you don't always know if they're police officers or not. And while there are a lot of policies from departments in New Hampshire and outside of New Hampshire that require officers to state who they are and where they're from, that doesn't stop people from impersonating police officers, and that's what we want to avoid here. Another aspect of this is for accountability. We want our police officers to conduct themselves, professionally, and also to respect the rights of people in their vehicle on the road. Their rights are always paramount. So we want to have accountability for police officers that go a little above and beyond with how they enforce some of the traffic laws, and a large issue that I think a lot of you have seen is some departments who hide a lot of their vehicles off the road. You can't see them from the road. They don't have any reflective, the lettering and emblems on the side of it, so you don't see it's there. You got to give people a time to comply. If they see a police officer, they can slow down, or if they were going to run a yellow light that may have turned red, they would stop because they'd see a police officer, and that might actually prevent a fatal accident, which I don't know if you guys have seen, but the rates of traffic accidents and fatalities in New Hampshire has gone up. It's gone up significantly. It's not just based on this issue. There's a whole host of issues as to why we are having more traffic accidents in New Hampshire. But the goal here is to make sure that everyone's complying on the road with the established, road laws. Pardon me for my speech impediment. One main issue that I like to harp on is that we still have civil asset forfeiture in New Hampshire, which would allow police departments to seize and then repurpose whatever they get from people to then use on the road to stop people with. And I think that is a practice in New Hampshire that we should not allow. I think every officer who would conduct those operations on the road should be clearly marked and identified, so that we trust that the person that we're interacting with is who they say that they are, and that we don't run into any escalation. So that's the section on the vehicles on themselves. I made the date for after the next year, so that any department in New Hampshire that would have an unmarked an unmarked vehicle that they would use to enforce road traffic laws, to the ability to be ready with either funding or to get rid of the vehicle that they would not be able to use if this bill was to go through, and that they would also be in compliance with the statute. I made the additional bill to have municipal police plates on the vehicle in case this bill did not pass. We would still have a fail-safe to at least have an identifying mark on any of the department vehicles that they would then use on the road. We all know what the state police vehicles look like, even if they're not marked. We see how they're fixed. We can see the state police plates on them, but not a lot of local police departments have that requirement or policy built in, and they use that for various stealth practices that I think could be in violation of the Fourth Amendment. The last thing I wanted to bring up is that I think that if we were to codify in the statute that all municipal police departments must be clearly marked, that would foster more trust in the institution of policing in New Hampshire, where we may not see a lot of the problems that a lot of the bigger states do, but we can at least say in New Hampshire that we do respect the rights and privacy of people to travel without being harassed, and to also travel and have the knowledge that they're going to be pulled over by somebody who has a flashing blue light on their vehicle, that they are who they say that they are. Anybody can buy a surplus or otherwise decommissioned police vehicle through auction, or just from a local used car sale place, and that person doesn't have the illegality of being able to buy certain types of equipment that they could then put on their vehicle and illegally harass people on the road as a non-police officer. So it's accountability for those people where it's already illegal to impersonate a police officer, so we'd be able to easily convict that person, but also more accountability for the police, that we can clearly see who they are, that they identify with the department that's hiring them to conduct those operations. But I also want to stress again that these two bills don't have anything to do with operations that are outside of enforcing road laws. So that if any police officer was to come up here to oppose the bill, special investigations are not in the scope of the bill. It's only what you see out on the road. So with that being said, I'll take any questions.
Thank you. I'm looking at the license plate bill first. Each municipal police department shall affix municipal police license plates on department-owned vehicles. No officer shall use any vehicle that does not bear municipal police license plates for the performance of official duties. That does not limit it to traffic. So for undercover purposes, oftentimes police will use a normal license plate. And oftentimes if you run that plate, it comes back to nobody, because sometimes, especially when you get into higher level drug investigations, the cartels and people actually have people that work in dispatch and things like that will run plates for those people so that the plate comes back to no one. Is it your intent that this should only limit traffic to traffic enforcement for the plates or for all the municipal police vehicles?
Ideally, it would be for traffic only. But I do think philosophically that if a police department would buy a vehicle for any type of operation, whether it's for special investigations or otherwise, that the vehicle should be identified as such.
Even undercover operations?
And well, in that case, no, but the
Okay.
scope is for traffic.
Okay, gotcha. Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. I actually have an experience with being pulled over by someone who I am still not sure if they were actually a police officer on a desolate Montana highway and had to pay for a ticket immediately. Right there, they're gonna, I don't know. I still don't know if this is a real police officer or not. But anyway, fortunately that was not in this state, but I understand what it's like to be pulled over and wonder. So this bill seems pretty good for addressing that in that moment. So my question to you is, sorry, it's taking me a bit to get there. The question is, would there be, the important part about that from my perspective would be so that people understand and can identify themselves if they're being pulled over, whether this is actually a police officer or not. And so my question is, would this be accompanied by education for people, particularly people who may likely be victimized or targeted, such as a single mom driving down the street at a desolate highway in Montana?
Absolutely. I think more people in the public should be aware, not only of the traffic laws, but also some department policies. They should be in tune with what the policy or what their department is doing with the powers that they have. And in that instance, I totally sympathize with the plight of a lot of the women who would encounter that, because we've seen in the news of assaults and robberies and stuff that have taken place, whether by a police officer or not. This is just one part of some reform that I figured would be easily amenable to even a lot of the more staunch police departments that say, like, well, we should be clearly marked so people can see who we are, and so that we can place our trust in them again.
Thank you.
Representative Salig.
Thank you. My question is related, I think, to Chairman Roy's. So with the license plates and the mandatory marking of municipal vehicles, I think about our detectives who often need to be in surveillance vehicles that don't have markings specifically for the purposes of doing appropriate detective work and safety work. But they also, if they're not in the process, or maybe even while they're in the process of doing their detectiving, whatever the terminology would be for that, if they see, for example, someone who is driving who appears obviously impaired, or perhaps someone driving down Main Street in Durham going 100 miles an hour on a 25-mile-an-hour zone, they have the ability to then stop that vehicle because it's a safety issue, right? And appropriate for them to make that determination. And I'm sure Chief Dean can attest to that as well. But so this requiring them to have municipal vehicles would make it so they wouldn't be able to do their detective work, and I'm trying to figure out how to make it work. And so perhaps you have an idea of how they can maintain their need to be in an undercover surveillance mode while also having a municipal license plate that identifies them as a police officer, which would negate their ability to be in surveillance.
I don't think in every instance a detective has to be undercover for them to perform whatever operations on their case that they need to do. I was more thinking of actual the patrol cars that we see every day. Obviously, like, I know that we have to have undercover operations for for certain types of cases. I did read that there are some states that do allow the pulling over with an unmarked police vehicle, but they're also required to call for a uniformed patrol unit to come assist with that stop. I think with how small some of our departments are, how small some of our towns are, I don't think it would be out of the ordinary for for them to do that if they had to.
Representative Stone.
Thank you, Mr. Chair, and thank you for taking my question. If this bill was to pass, wouldn't we be impeding on local control? Each municipality obviously has a governing body that sets the budget and allows for vehicles to be purchased. And by doing that, it gives the discretion to the local agency if they want to have, what type of vehicles they want to have and what kind of use they want to do, and as well as establishing their own policies. Do you feel that we'd be kind of treading on that if we were to pass something like this and limiting their control on what they can purchase and how they can utilize it? Since each municipality is uniquely different, whether you're in Claremont, Manchester, or Sunapee, or in your own hometown.
I think in the case where police departments are receiving, taxpayer-funded items or equipment, there should be accountability from the state as well. I understand what you're saying, but we're not seeing that kind of accountability on the local, like on the level where they would voluntarily be willing to be clearly marked and identified for the public. They would choose to rather hide on on the side of the road and not give people time to comply with whatever that they'd be stopping for. I believe that we have the right in the purview to keep our police police departments accountable, also with the state, but not just with the taxpayers.
So basically, this bill aims at a slang called a road pirate is trying to, curb that type of behavior is what the bill is intended for.
Essentially, yes.
Thank you.
Representative Jammern.
Thank you, Mr. Chairman. Thank you for taking my question. It's actually twofold, so I'll probably ask for a follow-up. On both bills, I've noticed that you are using the verbiage of any municipal police vehicle. To me, that means a local police department, which in essence is it your intent in your bills to exempt the state police, the sheriff and his deputies, constables, fish and game, and liquor enforcement?
I mentioned that in the beginning, that I didn't include the state police in this purview, for that purpose, that they, some of their highway operations require some of their practices, but I didn't include the state police on purpose.
And a follow-up. Also, and this is specifically to House Bill 1238, where you are saying that if they don't have a municipal license plate, they cannot be used for police purposes. That would basically prohibit a police officer who is operating on traffic enforcement detail to not use his personally owned vehicle. Is that correct?
Yes.
Thank you.
No, I don't know that that's what you mean. If an officer's doing a detail, he's just there standing outside, directing traffic, and he's brought his own vehicle. He's not. You don't intend that he can't bring his own vehicle to the detail. Is that what you're saying?
I'm saying that he should be in a clearly marked, identified patrol vehicle. Yes.
Okay. Who's left, Damon? Yeah, that.
Thank you. And thank you for taking my question.
Sure.
And this is going to piggyback on Representative Janneran's. So this does not apply to sheriff's vehicles, constables, fish and game as well?
Correct.
Just local police? Okay.
Correct.
Thank you.
Yep.
Representative Pratt.
Sure. Do you believe there's a value for police presence and visibility in a community to deter crime?
I'm sorry, say it again.
Do you believe there is a value for police presence and visibility in a community to deter crime?
100%.
Representative Wheeler.
Thank you, Mr. Chairman. Thank you for taking my question. Do you believe that, are there any states that have prohibited unmarked vehicles from being used in traffic law enforcement? And as a second part to that question, do you think that there would be any instance in which unmarked vehicles would be good to use in traffic law enforcement?
Good to use? In my view, no. I don't, but there are not that many states, no, that have outlawed it, prohibited. I'm just like in its entirety. They have some, some stipulations there where they could still do that, but there's always like, you can do this, but, and there are some states like here in New Hampshire where we don't have any, stipulations on how they're able to conduct their enforcement of road laws.
What would those other states be that have not full prohibitions, but like you said, sort of half you can do this when?
I should have that information. I apologize for not having that off the top of my head. But I can get that to you.
Thank you.
Yeah.
Seeing no further questions, thank you for your testimony.
Thank you, guys.
Thank you, ladies and gentlemen. I'll be brief. Appreciate the carve out for the New Hampshire State Police in this, especially that given that I drive an unmarked black Charger with a passenger plate, the record for which does come back to the Department of Safety, State Police. I'll do my best, ma'am, to avoid you in the future. But 42 miles between my house and headquarters. I'm classified more as a commuter than as a cop these days, and yet I make stops every day. I do take pleasure in being the answer to the question, where's a cop when you need one? At least a handful of times a year. I would argue that the goal of the law first is voluntary compliance. Whether a cruiser is present and within view is, in my experience, and much to my shock in many cases, not a material fact in the decision-making process of many a driver. That said, accountability is an important thing. Uniform is an important thing. State Police uses our marked plates when we're out on patrols. In an age where a mere 7% of serving police officers, some 10,000 who answered a survey from Caliber Press in 2020, 7% said that they would recommend law enforcement to people within their families, people within their spheres of influence as a career. We suffer an unprecedented lack of police officers out there, and some of those people are assigned to detective assignments and undercover assignments, and of course for undercover, it just makes good sense not to be applicable to them. But every holiday, you'll see a lot of blue lights out on interstates in particular, but small roads as well. I come from a rural troop. I am the community police. I grew up being the community police in that area, and when I go out on patrol, it's in those small areas, and so unmarked police cars are utilized by those employees to supplement the patrol numbers and to have effect to keep the public safe on the days where we expect higher traffic. I'm sure municipal agencies have, I know that they do, have similar situations for themselves and would support them in their ability still to do that. With regard to the question, sir, on what states outlaw or allow the use of unmarked cruisers, I'm a son of a state trooper. I remember my father talking about Rhode Island and Connecticut State Police, and I can't remember which of the two was notorious for actually using private vehicles. It was a Ford F-150, it was a Camaro, but in the case where any unmarked vehicles are used, and forgive me for not knowing specifically, given that my computer just died, but it was one of the two allows for the use of unmarked vehicles, provided that the driver is in full uniform. That said, I think it's still reasonable within our state to expect police officers to be able to identify themselves well. The use of body-worn cameras and the proliferation of other accountability measures have all been set to advance our accountability to the public, our requirement that we conduct ourselves with professionalism, no matter what it is that we're driving. And that's all I'll have. Go ahead.
Thank you, Mr. Chairman. Captain Davey, I just want to apologize. I wasn't asking you to hurry up. I was being sarcastic and saying, can you give us more information on the vehicle? And I think that might have been confused, and I apologize if you think I was being disrespectful to you. I was making a joke, actually.
Thank you. Not at all.
Representative Jamron.
Thank you, Mr. Chairman. And thank you for taking my question. I'm looking at House Bill 1237, which is the one that would prohibit them from being used for performing traffic law enforcement. Could you explain to me if the driving under the influence or driving while intoxicated laws are considered traffic law enforcement?
I would consider them to be so, sir, because they're within the motor vehicle manual.
follow-up. So if this bill were to pass as written presently, a police officer in an unmarked car could not make a motor vehicle stop for a DWI, a suspected DWI. Is that correct?
Yes, sir. If that were the interpretation, yes, you're correct.
Representative Bolden?
Thanks for taking my question. Are you aware of any studies or statistics related to whether the visible presence of a marked police car affects behavior? And if you're unaware, do you have a perspective on that?
Absolutely, ma'am. I have 22 years of experience of watching people behave exceedingly well while my marked cruiser was within their presence. I've seen it change behavior markedly, instantaneously upon the apparent apprehension of drivers that they're in the presence of a New Hampshire State Trooper. And I have seen just the slightest and most brief show of lights, for example, or the recognition by someone that I've got lights within the vehicle that I drive now, significantly change behavior. So, yes, ma'am.
Follow up.
So is it possible that marking more police vehicles that are on the road could reduce instances of criminal behavior or violations?
There's no question in my mind that more marked police vehicles throughout the world would likely have a desirable effect on driving behavior. It would probably help people to drive more safely. Yes, ma'am.
Representative Newman?
I was going to ask you about the blue lights, but your vehicle does have that. What happens if a police officer, if you were just commuting in your own car to work and there was some kind of traffic violations, what happens then? Do you do anything? Does that have any?
I don't, as a practice, do work in a personal vehicle. I have been involved over the course of my career in a handful of enforcement actions in really, really dangerous situations that required me to take action even though I was not on duty and not even in uniform. I don't know if that's responsive enough, sir. But.
Just to follow up.
The policy of the state police is not for its members to conduct traffic interdiction while off duty or out of uniform, is it?
It's strongly discouraged, sir, because it's an invitation to what may look more like a road rage incident than a law enforcement action.
Thank you.
Yes, sir.
Follow up, Representative. Okay. Representative Mannion.
Thank you, and thank you for taking my question. This is going to piggyback off Representative Bolden's statement. A question about marked vehicles clearly have more of an impact on people's behavior.
Mm-hmm.
However, do you feel that the need for these ghost vehicles, which are still marked, however it's subtle, still visible when lights hit them and stuff, do you feel that there's still a need for that type of enforcement in traffic?
I do. From a traffic safety standpoint, I'm actually a fan of unmarked vehicles, provided the other aspects of appropriate, professional, well-marked, easily identified law enforcement officers are in place. And to the Representative Newell's comment with regard to having been pulled over by a possible impersonator, I can say that the scope of that problem, as far as New Hampshire law enforcement is concerned, to my recollection, I can remember 2 within the last year or so, both of whom got figured out and snared up relatively quickly. So the scope of that is not severe to my knowledge in New Hampshire, thank God. And I'm sorry for your experience, ma'am.
Representative Newman.
I have a quick question just about in the situation that Representative Newell mentioned. What should a person do when a vehicle comes up behind them on a dark night and they have blue lights,
sir,
and stops them, but there's a concern about what to do in that situation? What should a person do in that
yes,
situation?
Sir. I'm a parent of 5, 3 of whom are young ladies who all drive, and my instructions to them would be call 911, get to a well-lit area, get to a public area where there's high traffic, go ahead and turn your turn signal on so it doesn't appear to be, an intention to flee necessarily, but have those protections in place. And if the person standing at your window doesn't pass the smell test, can't identify himself, show credentials without the window rolled all the way down, et cetera, then you have other decisions to make that'd be really
Follow-up?
terrible.
Follow up.
Would you consider telling your daughter to put the flashers on, the emergency flashers on instead of the turn signal?
Oh, I'd consider it, sure.
While I appreciate the Ask a Cop session, we are running late, so please keep your questions to the bill. Representative Selig? Okay. Any further questions? Representative Saitek?
Are blue lights illegal for, can only police use blue lights?
Yes, sir.
Okay.
I've issued
Thank
summonses
you.
for that.
Representative Wheeler?
Very quick, Mr. Chairman. Thank you. How long have unmarked vehicles been used in police work?
This bill?
Within the realm of detectives, decades. For multi-purpose vehicles within the state police anyway, we're approaching 15 years or so.
About 15 years for traffic stops for unmarked vehicles?
Yes, sir.
Okay, thank you.
Yes, sir.
See no further questions. Thank you.
Thank you.
The chair calls Elliot Axelman.
Hi, Elliot Axelman from Hookset, representing myself. I think on 1237 and 1238, the main thing I would say is police using unmarked cars or having license plates that don't denote them as police for regular traffic offenses is not appropriate. It's not a kind of policy that I would want in my state. I think the little bit I heard from the previous gentleman speaking, I suppose, in opposition to the bill, was I caught something about only 7% of police officers or their family would recommend the job because the overall support for them is not very high right now. I would say, I'm not sure, what exactly the point of that was. I didn't hear the whole context, but I think that when you're pulled over by an unmarked car or the black on black police like we have in my town where it's essentially impossible to see it's police, that makes people not love police a lot when they're undercover and they pull you over. Like I was pulled over at the Bow Concord border a few weeks ago by, I think, Bow Police. And he said, I noticed as you were driving, I saw your inspection sticker. It was the wrong color. It's from last year. Sorry. So I was pulled over for that, and I said, hey, it just expired. It was my birthday. I'll get it fixed. So I got a warning. But it's stuff like that. Every time there's a traffic stop, I think one of the few things that all the sides agree on, right, left, police, anarchists, traffic stops are inherently dangerous for so many reasons. People can get hurt. The police officers on the side of the road, especially on a highway, if one driver is texting or coughs or sneezes or looks down and they swerve off 1 inch, they can clip the officer. And now we have someone else is dead, someone else going to jail, someone else going to jail. We have orphans and widows. And it was one cop pulling over one guy for an inspection sticker. And now we have widows and kids without parents. It's very sad. And the risk reward, in my opinion, is not really worth it. Someone with an expired inspection sticker, probably would have survived, and now we have people dead. So police officers pulling people over, it's dangerous for them. It's dangerous for me. I carry 24/7. If you say the G word, the cop, very often will get afraid and they'll pull out their gun and maybe kill you. So we've seen a lot of those videos too, where anything wrong can happen. Where if he says, "Where are your hands? Get your registration. Move your hand the wrong way," people can get hurt. So every traffic stop, there's inherent risks, and everyone agrees on that. There's risks to everyone: the driver, the police officer, other pedestrians, drivers, and others in the car. So if we could, I would say, eliminate pretty much all traffic stops, unless there's a clear and imminent danger of someone swerving or driving 150, something like that. Routine traffic stops for like very much victimless, nonviolent offenses, which happens in New Hampshire, because New Hampshire is unique in that I don't know if other states have absolute primary offense. So technically every single thing in the universe that's on the inspection list, which is like 35,000 words, is a primary offense. So if your taillight, the light bulb on your license plate shining on it is not good enough, that could be a primary offense, and cops could pull you over. And you fail inspection, and the inspection people tell you they can't pass you if you have any tiny, even one little frame or one molecule covering your license plate, front or back. So there are a lot of little things that are primary offenses. Cops can pull you over if you have anything obstructing either front or back license plate. That has to be 100% clear. Not one molecule can be blocking it. So it's things like that you can get pulled over a lot. And I would say anytime we can diminish the amount of traffic stops there are, we can save so much risk to the police officers and others, and resentment towards officers because they pull you over. And I don't know a lot of people who like getting pulled over. And I'm happy to take questions in a second. And the other thing is the wasted productivity. The time is money. When I'm pulled over, that's the cop who's being paid by taxes, and me sitting on the road for 10, 20, 30 minutes, idling my car, polluting the environment with a collective, billion tons of CO2 over a year. And we're all wasting a lot of time and energy, and I'm missing time with my son because I'm on the side of the road talking about inspection stickers. So I'm happy to take questions.
Representative Reed.
Thank you, Mr. Chairman. So when your precious son grows up and gets his license and has a little bit of testosterone poisoning and just lets it rip, and wraps himself around a tree, I think at one point, maybe a traffic stop, you would have wanted that traffic stop before.
Yep.
How do you feel about that?
Yeah, that's a great question. So for a bit of background, I'm as anti-speeding and reckless driving as anyone. I'm a paramedic. I've worked in EMS since 2011. So I've seen the really bad MVAs, and I'm obviously a proponent of safe driving. I've taught safety driving for ambulances and regular cars for a while. And that's why I drive very conservative, especially with my baby in the car. I drive very slow and careful. I would say that the one traffic stop that's legitimate is for real reckless driving. So if he were 18 and he had testosterone, he were driving way too fast or in a way that is reckless. And we already have a crime of reckless driving, and any cop, they can all tell you, it's arbitrary. Any cop can pull anyone over for reckless driving, which is pretty broad, if they think you're driving too fast for the conditions or the road, regardless of speed limit. If they think you're driving, if it's raining and you're driving 35 into 30, like they can pull you over if you're driving recklessly. And I'm not that opposed to that, because if you're driving really recklessly, like if they say in their affidavit they believe within a minute someone was going to get hurt because you were driving so recklessly, they can pull you over. But inspection stickers, my license plate light bulb that shines on my plate not being bright enough or being out, or things like that, like I can't support those kinds of traffic laws, especially with an unmarked car that you can't see. So thank you.
Thank you. And thank you for your testimony.
Thank you very much.
The chair recognizes the Honorable Ellen Reed.
Thank you, Mr. Chair, and thank you, honorable members. It's a pleasure to be before you once again. I think I'll be before you again before this year is out. For the record, my name is Ellen Reed. I represent Newmarket and Newfields, Rockingham 10. I will speak conceptually on the bill. I am aware that the bill may benefit from amendments, including an amendment, potential amendment to exclude officers who see reckless behaviors while performing other duties like undercover detective work. I ask that the committee engage in the good work of taking the matter seriously and working on language that would be suitable for the state. I did want to bring up, before I bring up I have a personal story that only happened a month ago with regards to being pulled over by an officer not in a marked vehicle. But before I give you that story, I did want to address a couple things. Representative Janvrin brought up the issue of local control. As a Dillon's Rule state, we already impede local control pretty severely. We actually impede all municipal decisions unless we actively enable them. I actually prefer home rule myself, but there is a reason, even in home rule, there is a balance between a higher level of government and a local or more local level of government, and that is because it serves as a check and balance. Just as it does on the federal level, the larger level of government provides a floor of rights, and then local governments can build up from there but not sink beneath. It's the same with state and municipal. So that serves a function. My personal story is about a month ago, and I'm not like the previous speaker. I drive quickly. Is what I will say. I have a CDL license. I've been CDL licensed for, and perhaps the captain should cover his ears when I'm speaking about my driving. But I have a CDL license. Yeah, too late indeed. I've put nearly 1 million miles professionally in large CDL vehicles. In addition, I am a motorcycle enthusiast and have ridden in multiple states, Colorado, California, Florida, you name it. So when you put that many miles on, you get a little bit confident. And so I am a fast driver, and I was driving pretty quickly, but not recklessly and not, unreasonably beyond the rest of traffic on 95. And as I was driving, I was in the passing lane. As I was driving, and I was passing. As I was driving, I noticed that someone came up behind me and was tailgating me very, very, very closely and swerving very aggressively and hostilely. And my first instinct was to try to gain distance. He was that close. And then as I was able to, he stayed right on me, but as I was able to gain some distance, I noticed, despite the glare of the sun, the smallest little blue tint of a flicker in the headlights that had previously been invisible to me because the person was so close behind me that the headlights were not viewable. They were underneath my rear windshield view. So finally, I pulled over all the way, and this person in a Bruins jersey came out screaming at me. He did not identify himself by name or give me a badge number or show any identification at all. He simply said he was a state trooper. By the way, this happened in Massachusetts, not New Hampshire. And he was extremely hostile with me, directly yelling at me. And he actually said that he was about to call, and I don't even know what this is, but he was going to call for a pullover bar. And if it's what I think it might be, it means that he was willing to have my tires punctured in the middle of rush hour traffic. I don't know. But it was extremely hostile. And after he wrote up my citation, he threw the ticket into my window. So I give you all of this, and I don't want to suggest that New Hampshire officers are guilty of any of this. I've heard no stories to that effect, but I give you all of this because of the thought that every occupation attracts a certain personality type. If you like kids, you might decide to be a teacher. If you like helping people, maybe you want to go into nursing. For law enforcement, I hope and I believe that maybe even a majority of law enforcement officers got into it because they truly wanted to see justice done in the world and help people. However, if you are also a person who I guess colloquially we'd call on a power trip and you feel like you need to dominate others, those people are also attracted to law enforcement. I grew up in Memphis, which was the murder and auto theft capital of the country for multiple years as I was growing up. And our car was stolen 6 times as I was growing up. Police officers, in my mind, as I was growing up, were the good guys. So I don't want to say it's every officer, but when you have enough people in a department or in a culture, they're able to affect the culture. And my question is, how much more for someone who is thinking along those lines, who wants to dominate people, how much more emboldened are they if they lose the accountability that comes with showing up? And I realize that uniforms aren't part of this bill, but in uniform and in a marked vehicle. I think this is a Spider-Man quote, but with great power comes great responsibility. And they're really, in everyday society, police officers hold the most power. So therefore, they have to be held to the most responsibility. On the previous bill, actually, the captain, who I only have respect for, I want to make that very, very clear, said, and I tried to write down the quote as he was saying it, that the department would oppose, quote, anything that removes transparency, ownership, and culpability. But what else is having a marked vehicle than the transparency, ownership, and culpability of your actions? There's 2 other quick aspects to this I want to bring up. One is I am a motorcycle enthusiast, and there has historically been some relationship, both positive and negative, between motorcyclists and the law enforcement community. Generally, cruiser drivers, which I do ride cruisers as well, are seen favorably sometimes by some police officers. Generally, sport bike drivers, riders are not. And I actually sent a video, which I'm happy to share with the committee, of an unmarked vehicle officer in plain clothes pulling over a motorcyclist on a sport bike and approaching the rider with gun drawn and aimed at the rider for no other reason than speeding. So I think that speaks to like the mentality of certain officers, not all. The other thing I want to speak to is what Representative Newell brought up about the relationship between women who may be alone in their vehicle and officers. And this is something I found in 2020 and wanted to do something about it. There was an expose, a study across the country of police officers who engage in police detainee sexual offense. This is where a police officer picks up somebody, typically a woman, cites them for something, essentially threatens to arrest them, takes them around somewhere dark and tells them to comply or else they will go to jail. It's legal. This is legal, because there's nothing explicitly making it illegal in 35 states. At the time I found this out, I asked a former officer in New Hampshire if it was legal in this state, and the officer told me no. I took his word for it. In preparation for this testimony, I looked it back up. It is legal in this state, so I'm going to tell you right now, I intend to prime sponsor a bill next year, and I welcome any co-sponsors off of this committee to make it illegal. But it is legal in 35 states for an officer to have sex with a detainee so long as they claim it's consensual. There's a power differential, and we have a power differential in much of our sexual assault statute to show that that is an exacerbating influence. So I don't think it's okay for a police officer who has power over a detainee to have sex with them across this country.
That's getting kind of far off the bill.
Okay. My point in bringing it up, and I apologize for that, is that with these stories, these are police officers in marked vehicles with uniforms. They're still doing this, and it happens apparently once a week across the country. How much more emboldened are they if they are not wearing their uniform and are in a unmarked vehicle, is my question. So again, I appreciate the committee's time, but I do think it's something that needs to be taken seriously, and I hope the committee will work on it.
Thank you. Chair calls Chief Paul Dean. Thanks.
No questions?
I didn't see any.
Good morning. I'll be brief. My name is Paul Dean. I'm the Chief of Police for the University of New Hampshire and the third Vice President for the New Hampshire Chiefs Association, we're here speaking on. We're opposed to this bill. I'm not going to go into a lot of the things that have already been said. But I've not heard one example sitting there of a New Hampshire officer doing something. It's been all out of state people. And I think that's important for the standards that we use to hire law enforcement officers in the state of New Hampshire. I've been a police officer for 39 years, and I'm proud of the New Hampshire law enforcement profession. I'm proud of police standards and training, where we train all officers, whether they're campus police officers, state police officers, municipal or county officers, the same. And I know in that training that we are taught how to identify ourselves when we are in plain clothes. I also want to comment on the issue of asset forfeiture. The representative spoke about stopping a car, potentially seizing it and repurposing it for law enforcement. That's simply not the case. I am not aware in my 39 years, and I worked undercover for the Attorney General's office for a period of time. We seized cars, but we didn't repurpose them for use on the road for traffic enforcement. Most of the time, those were gone to auction and the money returned there. So I just wanted to comment on those areas there. Enough's been said, and I'll take your questions if you have any.
Chief, with regard to the points made by the sponsor and subsequent testimony from other people, including the representative who just testified, do you not think that for the purposes of traffic enforcement, it is better that our vehicles used by our law enforcement are marked?
Yes, sir, of course. But I do think that there's opportunities for us to use unmarked vehicles for specific enforcement in specific enforcement areas where the unmarked vehicle may be a deterrent, but is not able to stop things that are happening. In addition to that, I drive an unmarked vehicle. I can tell you that I only will stop a vehicle for a serious offense. And I think that's the vast majority of people who are in unmarked vehicles that are doing their jobs. And I want to just take a second to address Representative Selig when she talked about in Durham. We spend a lot of time dealing with underage drinking and the purchasing of underage drinking. And part of that is the transportation of alcohol. And whether you're a liquor enforcement officer in an unmarked car or a Durham or university police officer in an unmarked car, we do stop vehicles for that because we're in an undercover plainclothes manner. I would be concerned that a Durham or university police officer couldn't stop those cars, but a liquor enforcement officer could, or a sheriff's department could. I'm confident that we can manage these with training and policy. I'm also confident that Representative Finney comes from a good place when he's doing this. I do think training can handle that. I think police standards and training can be helpful in that, but I also think accreditation, which is now in the hands of police standards and training for many departments, can deal with that in policy.
Representative Stone.
Thank you, Mr. Chair, and thank you for taking my question. Chief, in your experience, would you say there's a distinct value for law enforcement to have the utilization of unmarked vehicles in everyday law enforcement?
I think it's a tool, and I think you're right. I think there is value to it, as in any tool that law enforcement has to protect the public.
Thank you, Chief.
Representative Manning.
Thank you. And thank you for taking my question. Is there a distinction between an unmarked vehicle and a stealth or ghost vehicle that you're aware of?
Not the distinction might be the cost of putting those decals on there. I roughly pay about $1,200 to have my police cars marked. I'm not so sure that's what that costs for a stealth vehicle, but they are marked up with stealth markings. Some are reflective, some aren't.
Thank you.
Thank you for your testimony, Chief. Is there wishing to testify on this bill who has not yet testified? Seeing none, I'm closing the public hearing on both of these bills, which are, for the record, House Bill 1237 and House Bill 1238. And we are done for the day, and I will see you all next Wednesday.